Hello friends, Mandar here. I'm back with another video. Today we are going to talk about some important tips on I-140 during your adjustment of status process. We'll also talk about some H1b tips and tricks. Because this is a H1b season, I wanted to make sure that I give out some tips that are very important so that you start on the right foot with USCIS. And also a new bill being created in the Congress that we shall talk about. So if you're interested in this topic, watch this video until the end and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration related videos for US and Canada. I'm not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. And for your specific immigration needs, before you take any action, you should hire a competent immigration lawyer. Now I have some affiliate links in the description, as I have been telling in the last couple of videos. So if you use those links to buy those products, it will help the channel. So I really appreciate that. The second thing is I'm working on an NFT project with one of the in partnership with somebody, and I'll be giving out more information in the near future. And then the third project that I'm working on right now is with the Canadian immigration lawyer to give out some information on how you can transfer your job from US to Canada if you are in a dire situation in the US in terms of getting your visa approved and being able to stay here. If that's your situation and if you are considering going to Canada, I have a live event that is scheduled on May 5th at 4 p.m. Eastern time. So make sure you have that on your calendar. Now the first point I wanted to cover is for H1b. Now this is an H1b season. We have FY23 H1b Cap subject lottery that was declared a couple of weeks back. Now whoever is selected in this lottery has been notified that their application has been selected. Now they have some time to submit their full application through their employer that actually sponsored their H1b petition. Now here are a couple of things that you want to make sure that you understand, especially because you are on H1. You probably went through your F1 process, you went through your university, and now you are in the job market. You probably have been doing the job on OPT or extended OPT up to 3 years now. So you are already in the job market, but you haven't been dealing with a USCIS a lot up until now. Now you have a critical situation here where you are transferring from F1 to H1, and now you are going to start your journey towards your green card in the future. So you want to be on your best foot with USCIS with this journey. The reason is because if you make any mistakes during this time, it is very critical and it might come back to haunt you in the near future. So what are those things? So when you have a cap petition that is approved in the lottery, and if you have an approval, then congratulations, you are about to get your H1b. You still have ways to go because you need to submit your documentation and then get an approval, but that approval is effective of October 1st. So remember that. So if you have your OPT, make sure that your OPT extends until 1st of October or at least until 30th of September, because your H1b status is not going to be active until 1st of October. That is the starting of your H1. So if you have a gap in between, that could be a problem. But talk to your lawyer how to fill that gap. Now second thing is, if there is a gap, don't do day one CPTs. That can come back to haunt you. The reason is because day one CPTs are given, that is a curricular practical training. So CPTs are given for the sole purpose of completing 1 year, at the least of 1 year of coursework. It could be more. So it is part of the curriculum, it is part of the degree that you are going to get. So CPT is tightly integrated with your studies and F1 visa. So if you violate those conditions, if you just use CPT as continuation of your work until you get your H1, it could pose some problem. Now what happens is some people just take an admission into some of those universities that allow you to start your CPT work, your curricular training right from day one instead of having them go through the coursework. The problem is if you do that and if you abandon your coursework and then do the change of status from F1 to H1, it might get denied because the officer will think that this, the only reason you went for CPT was to bridge the gap and you had no intention to study or complete your coursework. So that is a big negative on your part and you don't want to start on this wrong footing. So remember, this is a very important point. The second important point for all those H1 aspirants is, say there is a gap between when you apply for your cap subject petition in April and until you get the actual H1B in October 1st. So this is a long a gap, about 6 months. Now during the 6 months, make sure you don't change the job, because don't assume that you have an H1B already if your petition is selected and approved, even if it's approved. As I said before, it is effective of 1st October. So you cannot even change your job on assuming that you have an H1B and you can do H1B transfer. So this is a critical time. Don't change the job. Remain with your petitioner until you start your job with the H1B petitioner who petitioned for your cap petition. So once you get the approval, do make sure that you start the job with them as long as it's still available on October 1st, and then in future you may change the job with an H1B transfer, but don't do it before October 1st. That is also absolutely critical. And then the third thing I wanted to remind you about the H1B cap subject petitions is, you may have applied through multiple employers for this H1B, and USCIS loophole does allow you to do that. The problem here is only one of those petitions is going to be picked up and approved. So make sure that you work for that primary petitioner whose application was selected and approved for the H1B petition. You cannot go back and work for somebody else because they no longer hold your H1B. As I said before, once you start your job after October 1st, then subsequently you can change your job by doing an H1B transfer, but don't do it before that. So those were a couple of important tips that I thought were important for first time H1B petitioners whose application has been selected and who are going through the lottery system right now. And that brings me to the sponsor of this video, which is Surfshark. Surfshark is a VPN provider, and that gives you a lot of benefits that you are looking for. Now here is what all Surfshark has to offer. It gives you the power to protect your online privacy, control your personal data, access content safely, and unlock the exclusive benefits of this. What else can it do? You can browse privately, encrypt your internet activity so that no one can steal or track your data, hide your location. This is the key where I was talking about being able to watch the Netflix and Amazon from different countries, block ads and malware, stay safe on public Wi-Fi, keep searches private, and get real search results. And if you are in the tech or IT industry, you know what VPN can provide. Now if you click the link in the description with my code Mandar, you will get a discount, almost 83% discount on VPN deal, and plus 3 months of absolutely free VPN. So check out the link in the description, and if you do get the Surfshark through my discount code, it will also benefit the channel. Now let's switch gears and talk about I-140s. One of the most common questions that I get on my Patreon about I-140s is, here's the situation. You have been in the United States for a long time. Some employer in the past, maybe your original employer when you came here, they submitted your perm petition and they got your I-140 approved. Subsequently, you changed your job multiple times and now you are with a totally different company and they are processing your green card. So now you happen to be in this EB3 situation. So maybe your latest or current employer has petitioned for you in EB3 category and your original I-140 was in EB2. So now the question, a lot of people ask me this question: can I go back to my original EB2 petition? Now here's the thing: I-140 is owned by your employer, so you don't own the I-140. I-140 is a petition made by the employer on behalf of you for a permanent application, employment based permanent residence. So that one remains with the company. Now the only purpose you can use that previously approved I-140 from a previous employer is to recapture your priority date in the subsequent applications of I-140. So you can recapture that earliest priority date on your I-140 in any future I-140 applications that your future employers or your current employer is going to file. So that is the only reason, that is the only purpose you can use that original I-140. So now with the new employer, you are in EB3 situation. Now if you want to upgrade to EB2, the only way you can do that is to have your current employer file a new perm application, a new I-140 in EB2, and then you can interfile to EB2 petition. So that is the only way you can do it with your current employer. Now you can think about going back to your previous employer if you don't want to go through the perm and 140 again, which is not a bad idea actually. The other option is to go back to your previous employer and see if you have the similar kind of job still available where they can pick up your previously approved I-140 and just apply for your 485. So that is also possible. But I would say the previous option of remaining with your current employer and having them file perm and I-140 for EB2 is going to be a cleaner option for you. Another question I just want to reiterate, I have said it in my past videos as well. With such a hot job market right now, people are switching jobs left and right. Every question that I get on my Patreon is about the situation of job change. Can I change the job in this situation? Can I change the job in that situation? So it's very rare that people are staying in their job during this critical time. If you have a pending adjustment of status with your current employer in EB3, and now your EB2 date is current, and now you are changing, you want to change a job, you might want to think twice about it, because if you want to continue in your EB3, then there is no problem. You can just use the AC21 and change your job. Your EB3 adjustment of status will remain intact and you can go that way. But if you want to interfile right now with your current employer and immediately change a job, that is kind of a gray situation, and I have discussed this in the past. There is no need to take that risk of changing the job immediately after the interfile from EB3 to EB2. The reason is the USCIS has a rule of resetting the I-140, resetting the clock for AC21 job portability. So your clock for 180 days might reset. That's clearly what it says on the USCIS website. Nowhere does it say that your clock does not reset if you are using your previously approved I-140. So here's what I would caution. If you are in this critical situation of interfile, just wait for 180 days to change your job. That will be cleaner. You don't have to fight back with USCIS in case they drop your pending adjustment of status. So in order to avoid that situation, if you are interfiling with your current employer, wait for 180 days and then change your job to a new job. That would be my suggestion. As again, if you need my opinion on any of this, contact me on the Patreon site and I'll be happy to give you my opinion on it. Again, remember, it's a non-legal opinion. And now, as usual, Indian media seems to get the wind of anything that changes in the immigration in the United States first than anybody else. Now here's another bill that is being introduced which grants automatic right to H4 visa holders to work in the United States. So today, if you know, if you want, if you are an H4 and you want to work in the United States, you can only do so if you have an EAD, H4 EAD, and that is only possible if your main primary applicant has a approved I-140. So in that case, you can apply for an EAD and you can work in the United States. But by default, your H4 status does not allow you to work in the United States. So that is the reality today. What this bill proposes is you can automatically get right to work in the United States with your H4. Similar to what is there for the L2. L2 is the dependent of L1, and that gives L2 status gives them right to work in the United States. Similarly, they are saying they are proposing to have H4 status also eligible to work in the United States. So that is something new. US lawmakers have introduced a bill in the House of Representatives that aim at granting an automatic right to H4 visa holders in the country. So let's see what happens with this. There is also another law that is being brought up, as I said in my previous video, that has to do with the removal of per country cap, and also there is another one that has to do with recapture of all the green cards that were unused for EB category. Those were about 150,000 green cards that were unused. So all of these laws that are coming up, are being introduced are still not approved anywhere, and they have no chance of approval this year, in my opinion. So they may become law in the future or in the next year, but this is just for information what's happening in the House and the Senate. I just wanted to kind of make you aware of it. Now, as a reminder, I'm also working on that Canadian immigration lawyer and the company interview, and that is upcoming for 5th of May at 4 p.m. EST. So do check in at that time if you are interested. That's all I wanted to say in this video. If you like the content of this video, please hit the like button and consider subscribing to my channel, and I'll see you in the next one.